Welcome to The Explainer. Now, if you're a South African law student, you already know civil procedure can feel like trying to solve a giant, complicated maze. Well, don't worry. Today, we're handing you the map. We are going to walk through the entire journey of a civil lawsuit, from the very first problem to the final court order, so you can absolutely ace it. So, let's kick things off with a scenario that's super easy to picture. Someone crashes into your car, it's clearly their fault, but they just refuse to pay up. Now what do? This is exactly, and I mean exactly, where the law of civil procedure steps in. It's the official rulebook for sorting out private fights just like this one. All right, first things first. Before you even think about suing that other driver, you've got to know what kind of legal game you're playing. See, this isn't a criminal matter. Nobody's going to jail over a fender bender. This is a civil case. And understanding that difference is step one. It's absolutely foundational stuff for your exams. Okay, this table really breaks it all down beautifully. In your civil case, it's you against the other driver, just two private people. In a criminal case, it's the full power of the state versus an accused person. And check out the proof threshold. In a civil case, you just need to tip the scales slightly in your favor, what we call a balance of probabilities. But the biggest, most important takeaway here is the aim. Civil law is all about getting a remedy, getting your car fixed. It's not about punishment. And you know, civil procedure has this whole toolkit of remedies. It's way more than just getting cash for damages. A declaratory order, for instance, can clear up confusion over a legal right, say in a disputed will. An interdict, that can stop your neighbor from building a massive wall that's about to block your sunlight. And specific performance can force a seller to actually hand over the house they promised to sell you. So the key thing to realize is that the law has solutions, not just for when things go wrong, but to stop them from going wrong in the first place. Okay, let's get into the strategy. Once you decide you're going to court, you hit a massive fork in the road. You have to pick one of two paths. And trust me, choosing the right one from the get-go is absolutely critical. Your entire case can live or die on this decision. And that huge choice, it all boils down to this one concept. Is there a material dispute of fact? Put simply, do you and the other person fundamentally disagree on what actually happened? In our car crash, do you say the light was green and they say it was red? That right there is a material dispute of fact. It's a core disagreement the court has to solve. And this slide lays out those two paths perfectly. Path one, the action proceeding, is for when facts are in dispute, like our car accident. This is the long road with a full-blown trial and witnesses. Path two, the application proceeding, is the shortcut. You use it when the facts are clear, like if someone signed a contract to repay a loan and just isn't. That case is fought entirely on paper. And notice the names are different. It's plaintiff versus defendant in an action, but applicant versus respondent in an application. You've got to know that distinction. So, let's take a walk down that first path, the action proceeding. Our car accident, where both drivers are pointing fingers, is the classic example of a material dispute of fact. So we have no choice, we have to use an action. Let's see how that whole journey unfolds. Okay, get your highlighters right, because here's a Latin term that will definitely pop up: dominus litis. It literally means master of the suit. In an action proceeding, the person who starts the case, the plaintiff, is the dominus litis. You can think of them as being in the driver's seat of the whole lawsuit, responsible for getting the ball rolling and pushing it forward. Now, before anyone steps into a courtroom, there's a paper battle called the pleading stage. It starts when the plaintiff serves a summons. The defendant has to respond with a notice of intention to defend. If they don't, boom, the plaintiff can get a default judgment and win right there. Assuming they do defend, they file a plea, responding to every single point. The plaintiff can then reply with a replication. And once all that's done, we hit litis contestio, another Latin term. It means the pleadings are closed, the battle lines are officially drawn. The whole point of this paper exchange is to figure out exactly what everyone is fighting about. Okay, the paperwork is sorted. Now for the main event, the trial. And here, the burden of proof lies with the plaintiff. The old saying is 100% true: he who alleges must prove. But remember that standard of proof we talked about. It's not like in the movies where you need proof beyond a reasonable doubt. No, the plaintiff just has to convince the judge that their story is even 51% likely to be true, just a little more probable than the other guy's story. Now, here's a really cool strategic move the defendant can pull. After the plaintiff has presented their entire case, all their witnesses, all their evidence, the defendant's lawyer can stand up and ask for absolution from the instance. Basically, they're saying, Your Honor, their case is so weak, it doesn't even make sense at first glance. That's what prima facie means.
If the judge agrees, the trial is over. Just like that. The defendant wins without having to say a single word in their own defense.
And please, please, please remember this for your exams. Absolution is not the same as a criminal acquittal. They might seem similar, since in both cases the defendant doesn't have to present their side. But there's a massive difference. A criminal acquittal is final, thanks to the rule against double jeopardy. But with absolution, the plaintiff can actually come back and sue again later if they find better evidence. It's like getting a second bite at the apple.
So, if the judge denies absolution, the show goes on. The defendant gets to present their side of the story with their own evidence and witnesses. After that, both lawyers make their final, passionate closing arguments. Then, the presiding officer takes all the facts and all the law into account and delivers a judgment. Finally, a court order is issued. In our car accident case, the order would either allow the claim, meaning the defendant has to pay up, or dismiss it, meaning the plaintiff gets nothing.
All right, let's switch gears and jump over to that other path we talked about. This is the expressway, the faster, shorter journey you take when there's no real fight about the facts. This is the application proceeding.
So what's the biggest difference on this path? You can forget all the courtroom drama. There are no witnesses in a witness box. The whole fight happens on paper. All the evidence from both sides is presented in these super detailed, sworn written statements called affidavits. The claim, the defense, the reply, it's all a formal exchange of documents.
And applications generally come in two flavors. You've got the ex parte application. That's Latin for from one party. You use this when you're the only person involved and your request doesn't step on anyone else's toes. But if what you're asking for clearly affects someone else, you have to use an application on notice. You have to let them know you're taking them to court, and they then become the respondent in the case. Now, this is a really clever legal tool you'll often see with ex parte applications. It's called a rule nisi. It literally means a rule unless. What happens is the court makes a temporary order, but it's not final yet. The court sets a date in the future and basically sends out an open invitation, saying, hey, if anyone has a problem with this temporary order, show up on the state and tell me why I shouldn't make it permanent. It's a really fair way to handle things when you're not sure who might be affected.
Okay, so let's fast forward. You've gone through the whole process, you've made your case, and you won. The judge issues an order in your favor. Fantastic. But what if the other side just shrugs and ignores the order? What if they still don't pay? See, winning is just step one. Enforcing the win is a whole other chapter.
And that chapter is called execution. The person who won is now the judgment creditor, and the person who lost and has to pay is the judgment debtor. If the judgment debtor doesn't comply, the judgment creditor can get what's called a warrant of execution. This gives the sheriff of the court the power to go to the debtor's house, attach their property, meaning seize it, and then sell it at an auction to pay off the debt. But what if the debtor has nothing, no assets, no money, nothing to sell? Well, in the old days, you could actually be thrown in prison for that. But, and this is a massive landmark South African case you have to know, Coetzee versus the government changed everything. The Constitutional Court declared that it's unconstitutional to lock someone up just because they can't pay a civil debt. That practice is gone for good. Okay, but what if you're on the other side? What if you lost and you're convinced the court just got it completely wrong? Well, you're not out of options. You have two last moves. First, you can appeal. This is where you argue that the judge messed up on the facts or misapplied the law. Your second option is a review. This is different. Here you're not attacking the decision itself, but the process. You're arguing the hearing was fundamentally unfair, maybe because the judge was biased. So there you have it. We've mapped the whole thing out from a simple car crash all the way to a final enforceable court order. We've learned the rules of the game. But the sources we've looked at leave us with one last really big question to chew on. Is the game itself actually fair for everyone? And that leads us into the whole vital discussion around transformative civil procedure, which asks if these complicated, often very expensive rules truly give all South Africans equal access to justice. That's a crucial question to keep in your mind as you go forward.